Hello, everybody. It's Zach here from RealEstateLicenseWizard.com. How's it going today? Hopefully, pretty fantastic. Today, we're doing another real estate exam practice question. That's right. Today is question 158. It's a little bit of a long one, so let's just get into it. All right, so the question says a non licensed buyer negotiated the purchase of a house. During a conversation with the seller agreed to include both the washer and the dryer in the sale, and this was included in the sales contract. In this situation, if the seller takes the appliances, what recourse, if any, does the buyer have? And it gives us four options. So, A, the buyer can declare the principle of performance and trade any assets for what he has for the assets he wants. B, the buyer has no recourse because he negotiated the sale himself. C, the buyer may sue the seller for specific performance. Or D, the buyer may sue the seller for partial performance. So, like always, I'm going to give you guys an opportunity to reread it, come with your answer, think about it. So, go ahead and do that right now. Alrighty, so if you need more time, feel free to pause. If not, I'm just going to get into it. So, what is our answer? Well, our answer is going to be C. That's right. The buyer may sue the seller for specific performance. So, why is that? What does this mean? Well, specific performance is an equitable remedy in the law of a contract, which a court issues in order to issues in order requiring a party to perform a specific act, such as to complete performance of a contract. In our instance, since the washer and dryer were included in the contract, the buyer may sue the seller for specific performance. So I'm going to underline that right there. So, a couple takeaways with that. So, obviously, people get mixed up with this specific performance term. People think, oh, well, they technically, they did the contract and they sold the house, so maybe it's partial performance. Don't get confused with that. I think a good way of remembering this, the difference between specific and partial and, whatever else, is just think about if you were buying a house, or maybe one of your clients is buying a house, and something happens with their contract. They're going to be specific about it. They're going to be upset if one little issue is going to go wrong, because let's be honest, guys, this is their house. This is your house. They're spending a lot of money on this. If in the contract it was agreed that a washer and dryer would be in the sale, it better be in there. So it is very specific to them. It's important. Every little detail of the transaction is specific for them. So that's kind of a way that I think, at least I remember. I don't know if that'll work for you guys. If it doesn't, no biggie. Try and figure out whatever works best for you, obviously. But that's kind of how I remember it. Because again, I get all these people asking me all the time, oh wait, specific performance, partial performance, or principal performance, things like that. And just keep it super simple. Obviously, you guys should know by now. You understand your contract, you understand, kind of what goes into it. And if something goes wrong, a seller can sue for that specific performance. So understand? Hopefully, hopefully you guys got that one. But yeah, that's pretty much going to be it for this one. Hopefully you guys enjoyed. Don't forget to like, subscribe, all that good stuff for more. Thank you guys so much for watching. As always, this is Zach from RealEstateLicenseWizard.com. See you guys next time. Make today magical.